Thank you.
All right. You're smart. You're a smart man. Aaron, always appreciate it. Thanks, sir.
What's that? Oh, we got a whole thing in there. You good getting back there? Okay.
It's a challenge.
How are you? Good. The beard there. All rise. The Court of Appeal in and for the Fifth District of the State of Florida is now in session. The Honorable Harvey L.J., Chief Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the oral arguments of the Fifth District Court of Appeal. We have the privilege of being in Duval County with this special sitting. We also have the honor of having 3 Duval County judges on this panel. For those that don't know me, I'm Harvey J. I'm Chief Judge of the Fifth District. I'll be presiding today. To my right is Judge Soud, as many know, very good, fine, long-time circuit judge in this very courthouse. Before him, his wonderful father, with a wonderful reputation, served as a circuit judge in this courthouse as well. So I'm honored to be on the panel with Judge Soud. And to my left is Judge McIver, who I think has held every important administrative role in Tallahassee at some point or another, including being Chief Judge of the Administrative Law Judges. That's a big job. Boy, that's a big job. So thank Judge McIver for being part of this panel as well. For whatever reason, and I'm not exactly sure why, we've only got 1 OA this morning. We have 2 this afternoon, so it's a little bit out of the ordinary for us, but if all of you in this courtroom would be kind enough to make sure your cell phones are off, any electronic devices have been silenced, that would be greatly appreciated. If there is nothing else from the panel, we will get started with our one and only case this morning. That case is Nancy Jackson versus Florida Department of Transportation, case number 240202. Mr. Lee, who is presently at the podium, is there an amount of time you would like to reserve for rebuttal?
5 minutes, Your Honor.
All right, so noted. And when you are ready, please proceed.
Well, thank you, and may it please the court. My name is Brian Lee. I represent the appellant Nancy Jackson in this case. This case comes to the court from a summary judgment that was entered here in Duval County. And it was involving Miss Jackson's trip and fall that occurred on the sidewalk that was owned by Federal Department of Transportation, and then also another defendant in the case was Ferrovial Infrastructure, who had a contract with FDOT, or Department of Transportation, to inspect and maintain their premises as well. So the issues that came in front of the trial court had to deal mainly with notice, but also sort of mixed in within them the duty to warn or duty to maintain. And what the trial court found was that, and we believe sort of, out one side and another, is that it was so open and obvious to Miss Jackson that she should have seen it, which was a 1.5 inch raised sidewalk panel. But it was so, and I think the words of the district judge, or excuse me, the trial judge said it was minor or minuscule, that FDOT or Ferrovial wouldn't have been able to see it in inspections. Well, we know that both.
So part of your point, Mr. Lee, is that that's internally inconsistent, that if it was open and obvious, then they should have seen it. And if it's not, then maybe your client shouldn't have seen it as being open and obvious. That's part of your argument, correct?
It is, Your Honor, because, and I think really we have arguments that the duty to warn actually still is there, even if there was a determination, I guess by jury, that it was an open and obvious condition, meaning the raised part of the sidewalk. Duty to warn still becomes a duty for a property owner, even in that situation, when the condition is somewhere where the property owner knows people are going to traverse that area, and so this is certainly, and I don't think it's undisputed, it's sidewalk. I mean, people are walking through this thing quite often every day. And so,
What do you do, Mr. Lee? And it's a feature of the answer brief. And I went through and read the transcript last night, with your client's inability to say with, in the words of Ms. Klein, substantial certainty, where this happened. Is that a feature of our analysis as to causation, and your client's inability to say definitively, this is where I fell?
I don't think that is an issue, Your Honor, and I think the reason is because Ms. Jackson actually says where she trips. Now there is some back and forth, and she talks about, she was sort of, I think, testifying from memory as to how it looked. But when she was actually given a picture, there was a picture that was taken of the actual sidewalk, and I think it's actually within the answer brief. There's on that picture you'll see, which was the defense exhibit to her deposition, there's a circle on that, and it shows the half-inch part that's there. And in her deposition, when she's asked about that picture, I think it's page 374 of the record on appeal, and she's looking at the picture and she says, "I'm looking at the area that you designated to be the area that you believe you tripped at. That was the circle. Is that a rock?" Right? So she talks about, yeah, it's either a rock or a piece of a sidewalk. So she simultaneously says she tripped there.
Well, and I agree, Mr. Lee, the defense attorney helped you. I mean, he said the area you designated where you tripped. I saw that, but then after that, and I don't have the transcript in front of me, but after that, she seems to say, well, I'm just really not sure what happened. It happened so quickly. I mean, am I remembering correctly about that?
I think it's yes, you are remembering correctly, but it was the opposite. She did say that. She said, I just kind of don't remember where that is, and she was sort of going by memory. And I think it's after that part where then the picture's brought up. She's shown the picture, she sees the circle, and she verifies that where that circle is and where that rock is that she's designated, that's where she tripped. Right? So we have, yes, we do have the testimony that's before that is unequivocal. But when she's then given the picture and she's shown that, she certainly says that is the area, and that's the area that we're talking about here, as far as what I believe they're saying that they wouldn't have seen versus what we believe should have come up. And we have not only, this is a very rare case, cases that I normally see where Florida Department of Transportation, they typically do this. They will contract out the ability to inspect and to maintain and do those type of things. Normally, the Department of Transportation doesn't do anything after that. They don't do any kind of inspections. They kind of leave it to their, I guess, subcontractor or contractor. But in this case, we have a situation where they both inspected. Ferrovial did inspections, and it kind of goes through that in the record. But Florida Department of Transportation also said that they do annual inspections of this area. Now, I think they did 3, if I'm not mistaken, that the record says. But so there is this element that's not typically in the cases that I see where the Department of Transportation actually goes above Ferrovial. And when asked in the transcript why, they basically say, well, it's because we want to make sure they're doing what they're supposed to be doing.
So we know generally, and this is all black letter law, that there's a duty to warn about hidden dangers that the landowner knows or should know. And then second, duty of ordinary care to keep the premises in a reasonably safe condition. So explain to us, Mr. Lee, why the trial court was wrong as to either of those general duties here.
Sure. So for the duty to warn, from what I see from the trial court's order, is that the trial court said there was no duty to warn in this case because it was an open and obvious condition. The trial court made that finding, and that was around those the words the trial court used of minor within the order. The reason that is not correct, we believe, is that even when situations are open and obvious, or a trial court from the facts can determine that it's open and obvious, the duty to warn still takes place when it is a condition that's either something that they know people are going to transverse or they're going to have to go through. Number two, where it would not be open and obvious to the person. So open and obvious normally comes into this standpoint of whether it's actually truly open and obvious, or whether the dangerousness of it is open and obvious. Now, a half-inch portion of the sidewalk that's there, that we believe is obviously something for maintain. I'll get to that a little bit, but the open and obvious portion of that to Miss Jackson is not clear. There is no testimony from Miss Jackson that, whereas you see in other cases, plaintiffs have said, yeah, I knew that, indentation or that.
Is the existence of the commonality of uneven sidewalks or sidewalks which are generally in disrepair so common as to be open and obvious generally to Ms. Jackson?
I don't believe it is, Judge, because when you talk about common everyday things, I think it's a slippery slope. I'll say it that way, because yes, I do recognize there are the cases out there that talk about common everyday things that people should know. But I also see that as not taking away the duties that a property owner has, because if that were the case, I think that there would be no
Property
whatsoever.
owners expected to hang a sign on every tree root that runs under a sidewalk?
I don't believe so, Your Honor, but I do think that there are steps that they can take to be able to, to fix it if you need to inspect it, and all these things that we're talking about. Whether they saw it in time, whether they did enough to inspect, whether they maintained it correctly. Did they fix it 5 times and just kept doing it, or did they not see it for a year? All those things are these sort of factual issues that I think the case is put forward that the jury has to determine. It shouldn't be a court saying that, well, because that is there, and I've seen it there, and we've seen it there before, then that means we don't have to, the jury's not going to have to look at anything else other than to see that.
In the course of your very gifted argument, and of course you do a good job, and I say this not in tongue-in-cheek or anything of that nature, in the course of your argument where you're describing the half-inch variation at the levels of the sidewalk, you're holding your fingers like this.
Yeah, it's certainly this.
I mean, it's that.
It is.
So how does the reality of a half inch affect our evaluation of the trial court's determination of reasonableness?
Sure, and I think that although the cases that go through this sort of body of law doesn't actually say it, I think a lot of it does come down to things like the coding. Because we know that Florida Building Code talks about half-inch. We know that 88 guidelines talk about that.
That code relate to sidewalks, public sidewalks?
Well, in this case, there was argument that it did, because it was a means of ingress and egress. There is an argument there that, if it's in a building, is it not? Those types of things could come up.
Well,
I think that's maybe where courts get it, because there even are courts, and I've cited to them, that say that less than a half inch is something that could go to a jury as well.
Well, and we recognize, I think collectively, the cases are legion, where you have an overt building code violation and an expert coming in and saying this was dangerous because it violates the building code, and somebody gets hurt on it. That's a jury issue. The question here, though, is your expert, your client's expert, seemed to say something that may have been contrary to what the building code says. And when that happens, whose determination is that? Is it the expert, or is it the court to make that call?
I think that the court can do that type of analysis when you're dealing certainly with like Daubert motions and things of that sort, that, the expert can look at the opinion and see whether there's a foundational structure of the opinion, that scientific, is it in the community, those types of things. That didn't happen in this case. There was no indication that it happened. And
meaning there was no Daubert evaluation of that testimony.
Correct. And there was none of the things that normally courts look at in that type of analysis were done. This was a situation where the trial court just, I think, took what defense counsel's argument in their brief was and said, well, I'm not going to look at that expert testimony because I don't think it's valid testimony. I think that's ultimately what happened, because that's the only way that that the trial court would have been able to look past that testimony and still find for summary judgment. Because if the trial court, and as you say, there's black letter law on this, if the trial court were to find that there is evidence that could go to a jury of a building code violation, I think summary judgment you can't do it in that situation, because that is purely a jury question at that point. So I think the trial court would have had to have done that and totally discount that testimony, which we believe you can't do at this stage, unless there is that kind of analysis that's done, and it just wasn't done here.
Hypothetically, and I know this is not our case, Jackson, but suppose you have an open field and there's a sidewalk that's just going through the middle of this open field, not connected to any building. Everyone agrees it's not connected to any building. Somebody trips on that sidewalk in the open field, and the expert comes in and says, oh yeah, the building code applies to that, and it was a half an inch. And the building code says that's different than it ought to be, or 3/4 an inch, and the building code says half an inch.
Sure.
Is the expert allowed to do that, or does the judge have the right in that circumstance to say, as a matter of law, the building code doesn't apply?
Right, and I think that the judge in this particular case, sort of obviously it's different facts, but in your factual scenario, Judge, it matters what the building code says too, and the building code just unfortunately is not very clear. At least from the expert testimony we have, of what that is, right? And so it talks about things like appurtenances or structures and things of that sort, and it is not something that is very cut and dry. You've got a definition that you can't go outside. So there is a little bit of, the best I can say is wiggle room for experts to say that I believe that this comes with the building code. Now, could a court then say, well, I think as a matter of law it doesn't? I think
that's my question.
Yeah, right. It would be something where I think the court would have to have, as a matter of law, maybe not. As a matter of Daubert, if my expert came in and said that, and then there was 2 or 3 experts and there were studies and everything that says no, the definition, the way that expert says, has been refuted. The building code people have said it's refuted. I mean, all the things that you would normally see in a Daubert motion. If that were done, then yes, I think a judge could look at it and say, look, your opinion doesn't meet the standards of the community, of what this expert community says about what you're talking about. But there was none of that in this case. The expert had their opinion, talked about the definitions that went with it, talked about why it would be in violation, not just a building code, but other codes. And there wasn't anything from their side other than, well, he just doesn't know what he's talking about.
This is a little bit getting far afield, but I want to make sure I understand. You're arguing that the building code supplies evidence of duty. You're not saying that the building code is the law that establishes a duty. Is that correct?
Right. It's evidence of negligence. Right. So and building codes, I think even the most recent jury instruction literally says, you give the jury the building code and this is what it says, and it says this is evidence of negligence. It's not conclusive of negligence. It's your determination to determine whether that is negligence, right? Under the definition of negligence. So that's what we have here. That's all to the Warren part. I know I'm beyond my time, but just very briefly, the maintenance part of it, I think, is much more of a clearer situation, because we don't have anything. The only maintenance argument that I have seen is essentially, well, we shouldn't have to maintain it, because we could have hundreds of thousands of miles of stuff. Well, number one, there's no evidence of that. Number two, it's very clear that they knew they had a maintenance issue, or at least the duty to do that, because not only did they give Ferrovial the ability to do that, they themselves, meaning Florida Department of Transportation, came after them to make sure they were doing that. And so that argument, I don't believe has much merit as far as saying that we don't have a duty to maintain this sidewalk. There clearly was there, and the trial court found that there wasn't. because of a conglomeration of open and obvious, and you shouldn't have to maintain if you have all these sidewalks. That's the argument. I'll save the rest of my time for your brother. Thank you.
Thank you, Mr. Lee.
Good morning, Hinda Klein on behalf of the appellees. To start with, Your Honor, Judge Jay's question regarding the testimony of the plaintiff, we did raise that argument on summary judgment, and as you know, we've raised it in our brief, that the plaintiff was not sure that that was where she fell. She specifically testified, we were walking and the next thing I knew I was going down to the ground. I mean, it all happened so fast. That's pages 360 and 368 of the record. While she did make a circle around a picture, she said she thought that's what caused her to fall, and that's on page 373. And then on pages 418 and 419, she admitted that she couldn't testify with any certainty.
And I did read through that testimony last night, Ms. Klein, and I know it's hard to be a trial lawyer. I used to be a trial lawyer. I think the defense attorney may have helped a little bit, though. There's a question, the place you circled where you say you fell, and then she answers that question. Is that not enough to, at least on that issue, on the causation issue, isn't that enough to get it to the jury or not?
I don't think so. I think
Do you know the question? I think Mr. Lee referenced it during his argument.
I don't have the exact question with me, but
My recollection is, yes, you circled this area. This is where you told us your shoe caught or you tripped. And then she answered that question, which seems to me he helped her with something maybe she was not otherwise inclined to do. And no offense to the lawyer, but is that not enough, at least on that issue,
well,
to get us to the jury?
well, if you look at the Davy Plaza case that I cited, that's at 232 Southern 3rd 441. It's a 4th district case. Where handyman was injured when he fell off a ladder. He testified definitively where he fell, but he testified inconsistently in his depositions.
Aren't and I'm familiar with those cases, the handyman cases, you bring in somebody to fix something and they get hurt. And then they claim the very thing they were sent to do ends up injuring it. So, I mean, isn't that a feature of that line of cases or not, Ms. Cohen?
Well, in the Davy Plaza case, it was not. It was the property.
But you know what I'm saying, where
Yes.
you bring somebody in and they're there to fix the very thing they get hurt by. Well, that's probably something you shouldn't be making a claim for. But you're saying in this other case, it was different.
In Davy Plaza, actually, the landowner had not hired this handyman. It was one of the tenants. But the reason why the court reversed, and it was something like a $26 million verdict. The reason why the court reversed was because now he was deceased at the time of trial. He just simply could not testify with any certainty where he had placed the ladder. And while there was arguably a dangerous condition in the vicinity of where he claimed to have placed the ladder, he could not say that's where he placed it. And that is exactly on point with the facts in this case.
And it would be, but for that question and answer I just referenced. This is where your foot caught. But I mean, we just can't redact that out of the record, can we? Isn't that a little different than what you're describing? Now, if that was not there, you're correct. If she just said, I can't tell you what happened. I just know I went down. That's a completely different paradigm, it seems to me. So tell me why that analysis is wrong.
Well, because of the quote, next thing I knew I was going down to the ground. I mean, it happened so fast. I mean, I think she starts out by saying that.
She did.
So, she didn't get any more sure. Absolutely. I caught my foot and I tripped. She didn't say that. She just said, I went down. So,
I think you used the term in your answer brief, substantial certainty. Are there cases saying substantial certainty?
I don't think so, Your Honor, to be honest.
That was your term.
That would-
Okay.
In any event, there is a number of reasons why the court summary judgment, must be upheld here. Opposing counsel made a great deal of the open and obvious argument, and we all know black letter law typically, when you're talking about maintenance obligations, that oftentimes does not, permit a summary judgment on that issue, but there are exceptions.
What do you do, and you heard him argue, he argued it in the initial brief and in the reply brief, about the disconnect in the court's order saying this was open and obvious, but then saying they shouldn't have known about it because it was so de minimis. Isn't that inconsistent, Ms. Klein?
I don't think it is. I think something can be small but still open and obvious. I don't think that they're mutually exclusive.
True, but why wouldn't that put the landowner on notice of a problem then?
Well, because of, the cases that we cite that talk about, look, sidewalks have misalignments all the time. It's one of those things that everybody knows, that everybody should be prepared for, at least to an extent.
So your retort would be sidewalks, everyone knows sidewalks have these minor defects and there's nothing out of the ordinary about that. And she should have been aware of it, even though it was small, it should have been apparent to her.
Yes, I mean, every sidewalk has a seam, for example. I mean, it's one of those things that if you walk in any sidewalk, you should be aware that those are there. The Circle K case. There's a seam between the asphalt and the concrete. And the court said, yeah, it's unlevel, but listen, it's common, innocuous, and obvious. And that was a case from this court. The same with the City of Miami versus Wolf case. Again, a sidewalk that the court said was, substandard, but reasonably safe to walk. Otherwise, every slight depression in a sidewalk would result in a lawsuit. This court again, Gorin.
That brings me to my question. Where's that line? And it's something I'm going to ask Mr. Lee when he returns. Where is the line to be drawn?
I don't think there is a bright line. I think every case has to be examined on its facts, to be perfectly honest. And I think on these facts, it was common and innocuous. It was, not something that was sticking, straight up, like maybe a nail an inch above the sidewalk. But a certain amount of give and take in the sidewalks is to be expected. It's Florida, and every sidewalk doesn't last until the end of time. They obviously settle or crack or what have you. And that in and of itself, it renders it, so common and innocuous that it just does not give rise to liability. And, the Brookie versus Winn-Dixie case that we cited, makes it clear that an open and obvious defect can defeat a duty to maintain claim, just like a duty to warn claim, as long as it was not a dangerous condition as a matter of law, or it is so obvious that an invitee may be reasonably expected to protect themselves.
And I'm familiar with the Brookie case. That's Judge Thomas's opinion, Bilbrey's dissent. Isn't there an argument related to that case that it was open and obvious? I believe it's a pallet. But also that the sole cause of that was the plaintiff tripping over the hazard, he'd passed by the pallet, I think, 2 or 3 times before he fell. So isn't there a sort of a sole cause component baked into Brookie?
Well, Brookie says that there's 2 ways that you can overcome the duty to maintain, and that goes to the second way, and that is that the invitee may be reasonably expected to protect itself. So the court didn't really say this is not dangerous as a matter of law. What it says is you saw it, you knew about it, you acknowledged it, you walked around it, and therefore you fit within that second way to overcome the duty.
But that case, that case is a little unique. I mean, you've got a person walking by this purportedly dangerous condition that he walks by and then ends up tripping on the very thing he walks by 2 or 3 times. We don't have that here, do we?
No, and I'm not saying that we do, but we do have the first of those 2 prongs, the 2 exceptions.
And I think, and the case name escapes me, there's a Busch Gardens case, Middle District judgment, where a man, at Busch Gardens, I think holding his granddaughter's hand, walks into a tree limb over a sidewalk. Admits he saw the tree limb, gets distracted, and then hits the tree limb. That sort of reminds me of Brookie. That maybe the tree limb shouldn't have been over the sidewalk, but he appreciated the tree limb and then walked right into it after being distracted by his granddaughter. Again, I understand that. I understand why that would bar a jury question, a reasonable jury from evaluating those facts, but I don't see the sort of that causation prong here. Unless I'm missing something, meaning where it would be to the exclusion of a jury being able to evaluate it.
Well, the Circle K case talks about that first prong that we're relying on, which is that it's not only open and obvious, but it's not dangerous as a matter of law.
And Circle K probably is the closest case to what we have here.
Correct, and
The minor defect, so-called, and the person fell on it, and as a matter of law, our court said there was no liability.
correct, because it's common, innocuous, and obvious.
And it's been a while since I've read that case. What was the size of the defect there? Did they quantify it? Did the court quantify it in Circle K?
I do not believe so. It said it was an uneven ridge between the asphalt and concrete. So, no, they did not quantify it. But we submit, that the 3/4 inch, is basically the same, common, innocuous.
How do you respond to the expert argument? The plaintiff's expert saying the building code applies. Building code says a 1/2 inch is all you get. This is 3/4 of an inch. Violation of the building code, a dangerous condition. Jury question. What do you do with that?
Now, as we pointed out, this expert, he came to that conclusion without ever mentioning or really truly addressing whether or not the building code applied in the first case. And when we ask very specifically, he says, well, it can be interpreted that way. But the clear and unambiguous of the building language of the building code clearly doesn't apply. He didn't ever cite a specific section.
Whose call is that?
That's the judge's call.
Okay,
That is absolutely-
definitively 100%.
Definitively on we cited the Hand case and the Lindsay case, both of which say legal interpretations of the code are solely for the court, not the expert. But in any event, he clearly admitted that none of this applies explicitly to sidewalks, that the sidewalk in question doesn't, lead to a building. It doesn't, it's not a ADA ramp. It's none of those things that are addressed in the various codes that he cited. So it's simply him saying, because I said so. And that is legally insufficient to, preclude a summary judgment, especially when it's patently obvious that the expert is just flat out wrong. So they really had no other evidence that this sidewalk was anything other than, an ordinary sidewalk with minor misalignments. And the plaintiff clearly testified she walked this way every day. And on the date in question, she was walking back from, I guess it was a gas station. She had a bag in her hand. She was walking a dog. There's obviously other reasons that she could have fallen. I mean, maybe the dog just ran from her or what have you. But we don't have any evidence in this record that this is a dangerous condition. And we certainly don't have any evidence in this record that the appellees had any actual or constructive knowledge of this alleged dangerous condition. There was testimony talking about the inspections that both of these appellees made. But there's nothing that was even argued that these are insufficient inspections. Their argument that, well, you didn't see anything is kind of circuitous.
When the subject came up earlier of the miles and miles of sidewalk that would need to be inspected, I believe your opposing counsel said, first of all, that's not in the record. But is that the case? That was not in evidence?
I know that there was testimony from, let's see. I believe it was Richard Baum, who testified. I don't know if he actually said miles and miles. I have to concede that, but he did say that there were
Perhaps implicitly a lot.
a lot. Yes, I can't find it right now, but it's obvious that, there were a myriad of sidewalks in the area. And certainly not, less than 5 miles or, less than even 50 miles. I mean, there's just sidewalks everywhere. And in any event, they had no testimony of any kind of expert to say, well, you should be able to have inspected every inch of this every 6 months or something that they could rely on to say that somehow our inspections were negligent or below par. But they literally had nothing. Other than to say, well, you say you inspected, and we did, by the way, have testimony that we inspected this particular area, but I believe Mr. Baum could not specify exactly when that was. But again, without any testimony or evidence that anything that they did was unreasonable, then there's literally no evidence on which they could rely to defeat a summary judgment. They simply had nothing other than relying on an expert who was clearly wrong and saying, well, this is usually a question of fact for the jury, so we should pass on this. Well, it's very clear from the Supreme Court's adoption of the new summary judgment rule that that's not going to carry the day anymore. We don't have an obligation to disprove the plaintiff's case. They have an obligation to raise a genuine issue of material fact on which a jury could determine that we had actual or constructive knowledge of a dangerous condition and failed to fix it. They simply had nothing to say that anything we did was unreasonable. And we submit that under those circumstances, the trial judge was absolutely correct in granting summary judgment in our favor. Thank you.
Thank you.
Mr. Lee, if I could, my last question wasn't to prompt a he said, she said about the evidence that was presented. It was more because I'm curious. Let's say arguably there are miles and miles to inspect, or at least, as I said, implicitly a lot.
Sure.
Is the analysis of what is open and obvious different for the person who is present at the condition versus the person who has dominion over a large swath of area where the condition exists? In other words, what's open and obvious to the person who tripped might not be the same open and obvious to the person who is responsible for fixing it.
I think that's correct, Judge, and also that gets into sort of the second half of what I think the analysis is what does the property owner or the manager or whoever is looking at that, what do they know about it, right? So it's one thing for because that's two different factual patterns, right? If they never go out there and they never look at it, That in and of itself could be negligence but for another reason. But if they're going out there, they're inspecting and it's there for them to see, then that is another part of negligence that you could bring. There's really kind of two avenues of negligence that I see in these cases. And this one, frankly, is more of the more direct one because we know that there were inspections that were done there. We can certainly show that this was a condition that was not something that could have happened right away.
So did
You
I
know.
hear you say this is more of a maintenance case?
I think at the end of the day, it does become a maintenance case in the sense that, we can talk about the negligence and the inspection and what they didn't do, what they did do, didn't do. I was going to, maybe this is a good time to answer, Judge Stout, your
Where's the
question
line?
that you had given to my opposing counsel. I think the difference that you see in the cases, and there are differences, but the overriding difference that you see in Greer and those types of cases versus something like this and something like Middleton, which I'm going to talk about in a little bit, is who was the one that created the condition. Because in Greer, what we had was the Department of Transportation actually creating the condition. They were doing work on the roads and they had nails out there and they kind of left it there. And then, but it was Dade County's road, right? And so in that case, the court found, look, we're not going to put on Dade County what someone else did just because it's their public road. And of course, in that case, there was no question that there would be hundreds of, probably thousands of miles of road. And they talked about the smallest of the nail and things of that sort. But I think that's the difference. I think it's this difference where you have even a governmental entity that they're not the ones that really have dominion over it. They're not the ones that are inspecting it normally. Someone else is coming in doing the work. That type of thing is where you see this demarcation. Because in Middleton, after Circle K, after Kroll, which is another case that kind of buttressed the two of them, and now Middleton, this court does talk about the open and obvious conditions. And even in that case, there was a sidewalk. But the evidence, at least that I can glean from that decision, was that it talks about there was significant disrepair of the sidewalk. There was cracking. So I'm envisioning something where there's cracking everywhere. It's something you're going to see. And that was something that this court said, look, in this factual scenario, we do think that's open and obvious. They did sort of harken back to what Circle K said. But then they also, at the end of that, said, but that doesn't get rid of the duty to maintain. Even when the plaintiff in that case knows that they have the condition there, has seen it daily, because you know that you're supposed to maintain it. And in this case, I think we have both here. The duty to warn is not gone away with because there's no evidence that my client knew that this particular condition was there. There's zero evidence of that. But then on the other side, we do have evidence that they should have known about it. They were inspecting it. They could have seen it, and they have that duty. That isn't there. So for all those reasons, Judge, I know we went beyond time. We would ask that the court reverse the decision.
Thank you, Mr. Lee. It was well presented on both sides. We will be in recess until 2 o'clock. So thank you all.
All rise. Thank you.